Chuck, thanks very much for joining us tonight. Appreciate your time, sir.
Always a pleasure. Always happy to be on.
All right, so the Ninth Circuit Court of Appeals came out with a ruling on the Nordyke decision today. Have you had a chance to look at this?
I am still chewing my way through this. It is in some respects, it's pretty clear cut, but in others, there's a lot of nuance to this, and this is going to make for some very interesting follow-up litigation, I think, both in the Nordyke case, because it's still not over, 12, 13 years later, and in subsequent cases. Just so folks remember, Nordyke challenged the ban on the possession of firearms on county property in Alameda County, California. And the primary argument they made, this complaint is actually, the claims made in this case have morphed over the years.
Okay.
But what it came down to here was a Second Amendment claim, a First Amendment claim, and an equal protection claim. Now, the one that we were watching most closely was the Second Amendment claim, because that was revived as a result of Heller and McDonald, the two Supreme Court decisions. But preliminarily, you have to remember that the Nordyke case, it never really alleges that any of the plaintiffs wanted to carry guns onto the county fairgrounds property for the purpose of defending themselves while on that property.
Okay.
It alleged instead that what this law did by banning the possession of firearms on county property was make it impossible to hold a gun show and thereby make it impossible for people to buy and sell firearms that they need, obviously, in order to be able to use a firearm to defend themselves. So it's not exactly the same, and that was a critical distinction that the court drew. Mm-hmm. Now, what the court found was that since they hadn't alleged that this individual self-defense claim was implicated, that basically it's because people can buy guns in other places that it's not a Second Amendment violation, because it doesn't substantially burden the right to self-defense. Because you can buy guns in other places. Now, if they had alleged that it was and the court points out, if they alleged that it was impossible to get a gun someplace else, or that there were no, in fact, in the words of the court, the complaint does not assert that the ordinance makes it materially more difficult to obtain firearms, nor does it allege that there's a shortage of places to purchase guns in or near Alameda County. So the court, the big thing we were looking for in this case was some kind of a decision on what the standard of review was going to be.
Okay.
And we wanted straight up strict scrutiny.
Okay.
What we got is if the ordinance that's being challenged creates a substantial burden on the right to self-defense, then a heightened scrutiny up to potentially strict scrutiny applies. But you have to first establish a substantial burden. And what they're saying here is that the Nordykes did not establish a substantial burden on their right to acquire a firearm for self-defense. And interestingly enough, they're adopting really some of the same tests that are applied in the context of the right to the very hotly disputed, contentiously disputed right to an abortion.
Oh, really?
Yeah, so they're applying sort of the same tests that apply when you're challenging a law that restricts abortion.
Okay.
Now, I don't know how this is going to play out, because they never. What they did was say, this is the test that you should apply, and since the Nordykes didn't make this allegation, they haven't succeeded in a Second Amendment claim. But because so much as time has gone by, 6 years have gone by since they filed their last version of their complaint, of the actual document that constitutes the lawsuit, that they have a right to amend. So they may be able to go back and amend the complaint to allege either that this substantially burdens the ability to obtain a firearm, or that it substantially burdens people's right to carry a firearm, to possess a firearm, to defend themselves on the county fairgrounds. Now, the upside of this is that it rejects the anti-gun lobby has been advancing a couple arguments that were really sort of off the charts in terms of how much they wanted to limit Heller and McDonald. They were trying to say that there is a core fundamental right to self-defense, and that core fundamental right to self-defense is the right to possess a handgun in the home, and that's it.
That's it.
So they did not want to acknowledge that Second Amendment applied, or the right to self-defense applied outside the home. They wanted to make it end at your threshold. They wanted to say that the only thing that the Second Amendment protects is that core right, and everything else is not fundamental, is not an fundamental individual right. The Nordyke decision, it doesn't address that concept specifically directly, but it definitely goes way beyond that. It recognizes that, first of all, you might have a Second Amendment challenge to possessing a firearm on county property.
Mm-hmm.
So that's outside the home. So
Yeah.
it does an entire analysis of whether or not there's a substantial burden on your right to self-defense on county property. Well, it's not going to go through that analysis if it only applies in your home. So it rejects that. In fact, when it addresses one of the judges' dissents in here, because one of the judges was trying to go for essentially a rational basis or a reasonable basis challenge, which would be the lowest level of scrutiny, and the panel rejects that judge's proposal because it's too akin to a Second Amendment only protects this core right argument. So in that sense, it's really good. It rejects this reasonableness test. It rejects this, you only have this core little right that applies in your house. And it accepts that the Second Amendment exists and the right to self-defense and the right to keep and bear arms exists outside the home. That's gigantic in a sense. I'm sure we're going to see the Brady Center spin machine spin this as a victory tomorrow.
Mm-hmm.
But all the arguments that they've been making in most of the cases across the country just got shot down by this decision. So it's kind of a mixed bag. It's been remanded back to the district court, the trial court, from the Court of Appeals. Now, we'll see if it actually goes there. I suspect that Don Kilmer, the lawyer that's representing the Nordykes, and remember, the NRA has been doing amicus briefs and paying a lot of the costs associated with this case, and been helping to move this case along for 13 years.
Yeah.
But Don and the Nordykes are the one who are going to have to make the ultimate call. I suspect they may ask for en banc review, and for that matter, the county may ask for en banc review, Alameda County, because they don't like the fact that the panel rejected that core argument that they've been advancing. And it may even, one or the other of the parties may even ask the Supreme Court to hear this case before it gets remanded back to the trial court. So we'll have to, 13 years later, this case is still going strong. We probably have another 2-3 years of litigation in this thing, if you can believe it.
Unreal. Chuck, thank you so much, sir, for the instant analysis. I appreciate it. And if you find any more good nuggets there that you need to share with us, let us know, okay?
Well, there'll be a lot of chatter on this on the law blogs in the next few days, so I'm sure folks will be watching because all the lawyers are already chewing on this. It's going to be real interesting to see how this plays out.
All right. Chuck Michel, California civil rights attorney, joining us here on NRAnews.com and Sirius XM Patriot.